The question that we are going to go over in this lesson is freely available for download on the National Conference of Bar Examiners website, which is www.ncbex.org. If you'd like access to more practice questions like the one we're about to go over in this lesson, simply head over to the National Conference of Bar Examiners website and visit the section on preparing for the exam. From here, you can download tons of free practice questions directly from the National Conference of Bar Examiners. This is an awesome free resource I highly recommend everyone check out. Additionally, if you would like explanations to more bar exam questions in the format of this video, you can always head over to our website at www.studicata.com. But with that, I'm really excited to get into this lesson with all of you, so let's just go ahead and jump right in. In this lesson, we're going to go over a contracts bar exam essay question from the February 2011 multi-state essay exam. So step one with any of these types of essay questions, the first thing we always want to do is head down to the bottom of the essay first and take a quick look at the call of the question. Oftentimes, the call of the question is going to give us really important information to consider as we begin to actually read our fact pattern for the first time. So if we take a look at this call of the question, it tells us that designer was shocked and angered. He had counted on that money. He can prove that he would have gained $35,000 had he been able to make the planned investment. Designer has sued retailer for actual damages plus punitive damages. Question number one asks us, is retailer liable for breach of contract? Explain. Question number two asks, assuming that retailer is liable, can designer recover his actual damages from retailer? Explain. And question number three asks us, assuming that retailer is liable, can designer recover punitive damages? Explain. So a lot to unpack here from this call of the question. We clearly have a contracts question. It looks like designer here was promised some money. He's counting on that money, and he was going to use that money to make an investment. It looks like that was going to be a really successful investment for him. But we're assuming here, because he's suing retailer, he never got that money, so he was unable to make the investment. So he missed out on this $35,000 opportunity. This is kind of my takeaway from the call of the question. So he's suing for breach of contract, which is going to be number one. So we can kind of make an issue spotting checklist over here on the right side of the screen that we'll want to keep in mind as we begin to actually read the fact pattern. But we're thinking about question number one. It's all about the liability of retailer. Liability of retailer for breach of contract. So this is just going to be a standard breach of contract analysis. So in order for retailer to be liable for breach of contract, we need two things, right? Number one, we have to think, is there formation of a traditional enforceable contract? And if there is, has retailer failed to perform under the terms of that contract? So we have to think about formation and performance, right? Because if we have a traditional enforceable contract, we have formation, which we know is going to be offer, acceptance, and consideration. And there's no defenses to formation that might invalidate the contract, right? If we do get to that point in our analysis, though, where we have formation of the traditional enforceable contract, right? And we see that retailer has failed to perform his duties under the contract, that is how we get breach of contract. That's how we determine that retailer is liable for breach of contract, where we have formation of a traditional enforceable contract. There's no defenses that can invalidate the contract, and retailer has failed to actually perform his duties under the contract. That's how we find retailer liable for breach of contract. So that's kind of our major issues we're looking at with question number one. We get to question number two. Question number two is assuming that retailer is liable. Can designer recover his actual damages? So we're wondering, can the plaintiff recover actual damages? And actual damages are essentially what we call compensatory damages. Compensatory damages are made up of two components. We have general damages and we have special damages. Right? This is kind of what makes up actual damages. General damages are damages that are typically associated with breach of contract actions. Right? Think about the cost of storing rejected goods or transportation costs, right? Somebody breaches a contract. You have these goods now that weren't accepted. You have to store them. You acquire additional costs for the storage of these goods. This is very typical types of damages that are associated with breach of contract actions, or the cost to transport the goods that were not accepted to a different buyer now cost you an extra $5,000, right? These would be general damages, the types of damages that are typically associated with a breach of contract action. Special damages are a little bit more unique. Special damages, or what you might hear referred to as consequential damages, are foreseeable damages that are unique to this particular plaintiff in this particular breach of contract action, right? That's what we're thinking about with special damages. And usually there's two requirements we have to keep in mind with special damages, especially under an analysis of expectation damages, which is the default remedy in breach of contract actions. We say that these types of damages must, number one, be foreseeable, and number two, they must be provable with a reasonable degree of certainty. Right? Whenever we're thinking about special damages and expectation damages, we're thinking about whether the damages are foreseeable and whether those damages can be proven with a reasonable degree of certainty. And the reason I'm kind of highlighting this in my issue spotting checklist over here, and I'm kind of putting a star by special damages, is based on this part of the call of the question, where we see that designer was counting on that money, where he was counting on this money from retailer so that he could make a $35,000 investment. So he could make this investment that he had planned to receive $35,000, right? This is very much aligned with special damages, right? This is the type of damage that we would say is unique to this particular plaintiff. This is not something we typically think about in a breach of contract action, right? Typically, a person doesn't need the money to go make an investment and then try to get a return on that investment. Any type of fact pattern that looks like this, where somebody needs money to go make an investment, or needs the money to buy a lottery ticket, or needs the money to go start a business. These are not general damages that are typically associated with, run-of-the-mill breach of contract actions. These are unique to this particular plaintiff. That's what we associate with special damages. So when I'm looking at that and I see that designer had counted on a sum of money to go make an investment, and he's trying to prove that he could have gained $35,000 if he was able to make this investment, my questions are going to be, well, was that foreseeable in order to recover that $35,000? Because that's obviously going to be the major issue with question number two. The big questions are going to be, well, was that foreseeable? Did the defendant have some reason to know that he planned to make this investment? Was it foreseeable that he was going to go out and use the money that was promised to go invest the money to try to get a return on that money? How foreseeable was that? And can he prove this investment with a reasonable degree of certainty? Can the plaintiff show with a reasonable degree of certainty that had he been able to make the investment, he would have gotten the $35,000 gain? And it does look like in the call of the question, it gives that to us. It tells us he can prove that he would have gained $35,000 had he been able to make the planned investment. So it looks to me kind of like this is almost proven. The big question is going to be foreseeability. How foreseeable was it that he was going to use this money to make an investment? Did the defendant have any reason to know he needed the money to make an investment? Are facts we're really looking for as we read the fact pattern, and we're thinking about question number 2. Which takes us to question number 3. Question number 3 is still about damages. Assuming that retailer is liable, can designer recover punitive damages? Punitive damages. Right, so punitive damages, this is kind of a gimme of a call of the question. It's exceedingly rare in a breach of contract action that the plaintiff is ever going to be entitled to punitive damages. We typically do not associate punitive damages with breach of contract actions. Really, the only way that designer is going to be able to recover punitive damages in this type of breach of contract action is if there's some kind of tortious activity. Tortious activity, right? If there's some sort of tort intertwined with this contract question, then maybe we could get to punitive damages. But if there's no tortious activity, then there's probably no way that our designer can recover punitive damages in a pure breach of contract action. The way designer might be able to get punitive damages is if somehow we have tortious activity intertwined in this breach of contract action. So we'll be looking out for that as well as we read the fact pattern. But again, it's exceedingly rare that we would see that. But with all of this in mind, we can actually just begin to read the actual fact pattern, starting with paragraph number 1. And what we always want to try to do here as we read the fact pattern is kind of bucket each fact, each paragraph with the relevant issues we've kind of identified over here on the right side of the screen, right? From the call of the question, we identify these kind of issue spotting checklists, things that we're looking out for. Well, as we read the fact pattern, we want to try to bucket these facts with some of these issues we've identified. So we can start with paragraph number 1. Paragraph 1 tells us that designer and retailer entered into a legally binding contract for designer to maintain retailer's website. So we get a really important fact here in the first sentence. Designer and retailer entered into a legally binding contract for designer to maintain retailer's website. This gives us 2 critical pieces of information. Number 1, for the original contract that we see here, for this particular contract, we do not have to worry about any formation issues. When we're thinking about this contract, the first contract that's given to us in this fact pattern, designer and retailer entered into a legally binding contract. That tells us for this contract, we don't have to worry about offer, acceptance, consideration, defenses to formation and enforcement. We don't have to worry about the statute of frauds because this is a legally binding contract, right? So we don't have to worry about any of these formation issues for this contract. Now, as we go through this fact pattern, if we see additional facts, the contract is being modified or there's a second contract, right? There's ways that these issues can come back onto the table. But right now, we have a legally binding contract stipulated in sentence number 1. So right now, we're not as concerned about offer, acceptance, consideration, defenses to formation, statute of frauds, less concerned with, right? We're really thinking more along the lines of performance at this point in the analysis. Also, the contract is for designer to maintain retailer's website. That tells me right there, this is a service-based contract. So we're going to apply the common law in this analysis. We're not applying Article 2 of the Uniform Commercial Code. This is not a purchase or sale of goods. This is a service, right? Designer is maintaining retailer's website. That's a service-based contract. So any law we're applying here is going to be the common law, not Article 2 of the Uniform Commercial Code. Okay, next, the facts tell us that Under the terms of the written contract, retailer was to pay designer $20,000 per year. Retailer made timely payments for 2 years. Okay, so not entirely clear here. This paragraph just seems to kind of be setting up the fact pattern. I'm not seeing kind of exactly where we bucket this yet, so I'm just going to keep reading more facts. 8 months before the 3rd year's payment was due, designer learned of an investment opportunity. Designer called retailer and said, I need cash quickly to make an investment that will enable me to make a $35,000 profit. I know that you owe me $20,000, but if you promise now to pay me $15,000 in cash by the 25th of this month, I will accept that payment as satisfying your obligation under our contract for this year. So a lot to unpack in this paragraph. The biggest thing that's jumping out the page to me as I read this is that designer calls retailer and says, right? Designer called retailer and said, I need cash quickly to make an investment that will enable me to make a $35,000 profit. So designer puts retailer on notice of this investment opportunity in the phone call. This goes back to foreseeability when we're thinking about actual damages in question number 2, and we're thinking about the foreseeability of the damages, of that $35,000 that we know he's missing out on because we've already read the call of the question. We now see that designer calls retailer and puts him on notice. He says, hey, I need the money now to make an investment. So at that moment, our defendant, right, retailer, has notice of this investment opportunity. He has reason to know of the investment, making this seemingly foreseeable to me. So it does look like if we are assuming that retailer is liable, right? If we say, okay, retailer is liable for breach of contract, and we're trying to determine whether designer can recover his actual damages, and we're focused on those special damages, that $35,000 potential investment profit, well, it does look like it is a foreseeable investment, right? Because he tells the other side, hey, look, I need the money now to make an investment. So he puts the other side on notice. So it does seem foreseeable. And then the facts tell us that he can prove that he would have gained $35,000 had he been able to make the planned investment. That goes to, it does seem that he can prove these damages with a reasonable degree of certainty. So I'm already thinking if, and we are in question number 2, assuming that retailer is liable. So if retailer is liable, it does seem likely to me at this point that designer will be able to recover that $35,000, those special damages unique to him, because those damages are foreseeable and he can prove them with a reasonable degree of certainty, right? So that's kind of all where I'm leaning on question number 2. So this first part of the paragraph, I'm kind of bucketing back to question number 2 when I'm thinking about special damages. The second half of this paragraph, right? I know that you owe me $20,000, but if you promise now to pay me $15,000 in cash by the 25th of this month, I will accept that payment as satisfying your obligation under our contract for this year. This sounds to me like a proposal for modification of their existing contract. So they have an existing contract. Paragraph 1 tells us designer and retailer entered into a legally binding contract. Now designer calls retailer and proposes this modification. He says, I know that you owe me $20,000, but if you promise now to pay me $15,000 in cash by the 25th, I will accept that payment as satisfying your obligation under our contract for this year. So the second half of this looks like it goes to Q1, liability of retailer, right? Because this goes to whether or not there is a traditional enforceable contract. Is this second contract, this proposal basically for modification of the contract, is that going to control? Is essentially the modified contract going to control, or is the original contract going to control? Is basically now our major issue with Q number 1. With question number 1, we're thinking about liability of retailer. and we're thinking about our first question of formation, well, we know we have one legally binding contract, right? The facts tell us this in the first sentence. Now we get this proposal for a modification. The question is now going to become, okay, do we have a new modified contract that's going to control, or does the original contract from sentence number 1 control? So this is going to question number 1, and it's essentially an offer to modify. So we get this offer or proposal to modify the contract. Let's see what happens. Retailer responds, "Thanks, that's a good deal. I don't have the cash to pay you now. I'll do it if I can get a loan." Okay, so this is a pretty standard counter, right? We have a counter offer. So the original offer is now terminated, right? The offer or proposal to modify the contract that's given by designer to retailer basically is now terminated, and we have a counter offer to modify put on the table. Right? Retailer responds. So now retailer makes a new offer that says, "Sure, I'll do it if I can get a loan. I'll do it if I can get a loan." We also have an express condition there, and that might become an important fact. He says, "Yes, I accept if I can get a loan," right? So because he's added different or additional terms to this, it is a counter offer that terminates the original offer. We now have a counter offer at play. Let's see what happens. Right after this, we see that designer accepts. Designer says, "That will be great." That's clearly an objective manifestation of willingness to enter into the agreement. That's a clear acceptance. So we have counter offer and we have acceptance of the counteroffer. So at this point, we have a new valid modified contract so long as our rules for contract modification are satisfied. But the manifestation, the mutual assent requirements are going to be met. When we're thinking back to formation and we're thinking about offer and acceptance, we clearly have offer and acceptance for basically a new modified contract. The next question in formation after offer and acceptance we know is consideration. So we will have to verify when we get to this stage in the analysis for Q1 whether there is valid consideration for this modification. And we know this contract is governed by the common law because it's for services. So we'll be applying the rules for contract modifications at common law, not the UCC. Right? At UCC, under Article 2 of the Uniform Commercial Code, we know a contract modification is valid if it's made in good faith. Under common law, we know that there's a requirement for additional or new consideration, right? Contract modifications at common law must be supported by additional or new consideration. And we know we have to think about the pre-existing legal duty rule or the pre-existing duty rule in that analysis. Anytime we have a contract that's being modified, well, contract 1 sets up all these pre-existing duties. We need a new duty to kick in order for there to be additional consideration, in order for this modification to be valid at common law. So we'll get to that when we get to our analysis there, but that's the major issue. It does look like we have offer and acceptance for this proposed modification. So the real question is going to be whether there's consideration. We know that's required for a contract modification at common law. That's going to be our major issue for the first part of Q1 when we're thinking about formation. Okay, but we can keep reading here. After designer responds, "That will be great," the facts tell us retailer, however, was busy with other matters. He visited 2 banks and picked up loan applications, but he never bothered to submit them. Retailer did not take any other action to obtain a loan before the 25th of the month had passed. This all goes to performance of the contract. This is Q1 still. This is about the liability of retailer. And so this tells me if we have formation, if we have an enforceable contract, if this new modified contract controls, right? Because we know we start with a legally binding contract. Sentence number 1 tells us this. And then we get this proposal for a modification. If the modification is valid, then we know that new contract controls. And the new contract, or that new modified contract, however you want to think about it in your head, is either a new contract or this new modified contract, right? We know the term here is that he's going to do it if he can get a loan, right? There's this express condition. And we know the non-occurrence of a condition discharges performance under the contract. So if he's unable to obtain a loan, then it discharges his duties under the contract. That's the non-occurrence of an express condition. However, we also know that all contracts have an implied duty of good faith and fair dealing, right? And so anytime we see somebody saying, I'll do this if I can get a loan, there's going to be a duty of good faith to take reasonable steps to actually acquire that loan. And here it looks like, he never bothers to submit. If we're looking at these facts, he never bothered to submit them, right? So he goes and he picks up loan applications, but he never even submits them. And he doesn't take any other action to obtain a loan before the 25th of the month had passed. That seems like a violation of the good faith and fair dealing, right? That seems like a good faith issue. If the second contract, this modified new contract controls that has the express condition of it for this guy to go obtain the loan, right? That means he has to take reasonable steps, right? He has to exercise good faith to try to acquire the loan, meaning he has to take reasonable steps to get a loan. So if this new contract controls with this express condition in it, and he fails to exercise good faith to go and get this loan, that's going to be a breach of contract. It's a breach of an implied obligation of good faith and fair dealing that's present in every contract. It doesn't matter whether the contract says you have to act in good faith or not. It's implied in every legally binding contract that both parties have to operate in good faith. So if you say there's an express condition to obtain a loan, you have to take reasonable steps to actually go get the loan. Failure to do that is a breach of the good faith and fair dealing, implied obligation in the contract. And because it looks like he never bothered to submit the loan applications and retailer doesn't take any other action to obtain a loan before the 25th of the month had passed, that seems like a violation of good faith. So that again goes to question number 1, liability of retailer. That's where we're going to find this breach. When the 25th, and we can go to the next paragraph now, when the 25th of the month passed without payment from retailer, designer telephoned retailer. The moment that retailer heard designer's voice saying hello, retailer quickly said, "Sorry, but I can't take you up on your offer to accept early payment." So this is a revocation attempt, but it fails, right? This is very obvious. This again goes to question number 1, the liability of retailer, right? We know that an offeror is free to revoke his offer at any time prior to acceptance. But once acceptance happens, right, revocations are no longer valid. Okay, so here we already established that there was offer and acceptance. So neither party can revoke after acceptance happens. This is just an invalid revocation attempt, right? So this paragraph is almost a little bit of a red herring. It's not really going to substantively affect our analysis that much. Right, when the 25th of the month passed without payment from retailer, designer telephoned retailer. The moment that retailer heard designer's voice say hello, retailer quickly said, "Sorry, but I can't take you up on your offer to accept early payments." Right, it's a rejection attempt. Sorry, it's not a revocation attempt. I meant to say this is a rejection attempt. And we know that the rejection would be valid if it happened before acceptance, but this happens after acceptance. So the rejection attempt here is invalid. Okay. Next paragraph. Designer was shocked and angered. He had counted on that money. He can prove that he would have gained $35,000 had he been able to make the planned investment. This is again the call of the question. Designer has sued retailer for actual damages plus punitive damages. Question number 1 asks us, is retailer liable for breach of contract? I think we've identified all the major issues here. We can just move on to the points here that the bar examiners were looking for from examinees, and we can start with question number 1. Right here for point 1A, worth 40% of this essay, the bar examiners were looking for examinees to conclude that designer made an offer to retailer to modify their existing contract. Retailer did not accept the offer. Instead, retailer made a counteroffer, which designer then accepted, forming a modified contract. So this is exactly what we talked about, right? Designer makes an offer to retailer to modify the contract. Retailer does not accept. Retailer makes a counteroffer, which designer then accepted, forming a modified contract. So this was just a very basic formation, offer, and acceptance analysis. Right? We know step number 1 in determining liability of retailer is going to be, well, did we have formation of a traditional enforceable contract, right? So we're always thinking, was there formation of a traditional enforceable contract? In order to form a traditional enforceable contract, we need offer, acceptance, and consideration. Here, the offer is very clear. And this, by the way, it is a contract modification, but we're still applying to determine whether this modification is valid. The proposal for the modification is an offer. It has to be accepted, right? So we do have an offer very clearly in the form of a counteroffer. Retailer says, thanks, that's a good deal. I don't have the cash to pay you now. I'll do it if I can get a loan. That's a clear, objective manifestation of willingness to enter the agreement. He says, I'll do it if I can get a loan. So that was our offer. Responding, that will be great, right? Where designer responds, that will be great. Clear, objective manifestation of willingness to enter the agreement. That's our offer and acceptance. The larger part of this analysis, to me, when we're thinking about an offer to modify the contract and then the acceptance to modify the contract, the bigger issue was whether there was valid consideration, right? In this, we had to know, number 1, that we're applying common law rules because this is a service-based contract. So the common law controls here. And under the common law, a contract modification must be supported by consideration. The major issue in terms of consideration in contract modifications at common law is the pre-existing duty rule. We have the pre-existing duty rule. The pre-existing duty rule stipulates that a promise to do something of which the party is already legally obligated to do by contract is not consideration. So here, the party already had the obligation to pay $20,000 by the end of the year, right? If we're thinking about this, under the terms of the written contract, retailer was to pay designer $20,000 per year. So the original legally binding contract we have, we see that retailer has a duty to pay designer, right? So we can say retailer has a duty to pay designer $20,000 per year, right? $20,000 per year. And we're assuming there that means by the end of year. So we can actually change this to $20,000 has to be paid by end of year, right? That's the original duty that retailer owes to designer under the original contract. This is the pre-existing duty, right, that retailer owes designer. The key here was under the modification, right, we're actually now saying, if we go back to the paragraph on this, designer called retailer and said, I need cash quickly to make an investment that will make me a $35,000 profit. I know that you owe me $20,000, but if you promise now to pay me $15,000 in cash by the 25th of this month, I will accept that payment as satisfying your obligation under our contract for the year. So here, retailer designer is saying, I know you owe me $20,000, but I'm going to accept $15,000 if you pay it by the 25th, right? And so the key here was the timing by the 25th. Without that stipulation here, this would be essentially a violation of the pre-existing duty rule. It would not be new or additional consideration, right? Because we see that retailer already has a duty to pay $20,000 by the end of the year. However, under this proposed modification, if it wasn't for this timing requirement, it was just, okay, we're switching this from $20,000 by the end of the year to $15,000 by the end of the year. Well, he already had a pre-existing duty to pay $20,000. Switching that to $15,000, there's no additional consideration. That would be an invalid contract modification, and the original contract would control at common law. The reason that this is going to be valid consideration is because we're changing the timing requirement. Under the original contract, retailer has a pre-existing duty to pay $20,000 by the end of the year. In the modification, retailer now is paying less, but he has to do it by the 25th, right? He has to do it by the 25th. Because of this new detriment that the retailer is taking on, this is going to be new consideration, right? The promisor, designer, is promising to accept less money. The promisee, retailer, is taking on the detriment to pay early. Clearly, the promise induces the detriment, and the detriment induces the promise. This is clear bargained for consideration. So the contract modification is supported by additional consideration. The key here was the reason this is not a problem with the pre-existing duty rule was this timing requirement. That's the new detriment. Yes, he's paying less money, but he has to pay sooner than he had to under the original contract. That's the new legal detriment he was not otherwise legally obligated to undertake. That's the additional consideration. And clearly, the promise to accept less money, right, induces the detriment. The detriment induces the promise, and the promise induces the detriment. So we have the bargained for consideration. That was point 1A. That forms our modified contract. So we have formation of this new modified contract, right? We can say, okay, so they did properly modify the contract at common law. We have formation of a new modified contract to determine whether there was a breach of that contract, whether retailer breached the contract. The question is, well, did retailer fail to perform a duty under the contract? And this gets us to the implied duty of good faith and fair dealing. In general, every contract contains an implied duty of good faith and fair dealing. Here, retailer has an implied obligation under the contract to make good faith efforts to obtain the loan, right? Remember, the new term in our contract, our new modified contract, is that he's going to do it. He's going to pay the $15,000 early if he can get a loan, right? These are the new controlling terms of the contract. So when he says that, I'll do it if I can get a loan, he has to take reasonable, good faith steps to actually obtain the loan. Here, retailer does not take those reasonable steps. This is our paragraph right here, where we see that he visits 2 banks and picked up loan applications, but never bothered to submit them, and he takes no other action to obtain a loan before the 25th of the month. This is a breach, right? Retailer breached the contract by failing to make good faith efforts to obtain the necessary loan. The key here was you had to recognize that every contract contains an implied duty of good faith and fair dealing. So this was a breach of an implied duty, right, under the contract. So we have formation because the contract modification is supported by additional consideration. We have offer, acceptance, consideration. There's no defenses to formation that invalidate it, right? That gives us this new modified contract. So he has a duty under the new modified contract, retailer does, to make good faith efforts to obtain the necessary loan. He fails to do that. That is our breach of contract. Right now, if he had taken good faith efforts, he submitted the loan and he just didn't get approved, right? His credit was too low, but he did everything that he could. He made all the good faith efforts. Well, that would be totally different, right? The non-occurrence of a condition discharges performance. So his performance would have been discharged based on a non-occurrence of the condition, so long as he exercised good faith. But because he failed to exercise good faith in obtaining the loan, that's our breach. That was point 1B, worth 30%, which takes us to question number 2, which was all about damages. Here, for point number 2, the bar examiners were looking for examinees to conclude that designer is entitled to recover from retailer his actual damages, which would include the gain that he would have realized on the investment he intended to make. So again, if we're thinking about actual damages, we already kind of talked about this. Actual damages or compensatory damages consists of both general damages and special damages. General damages are damages that are typically associated with breach of contract actions. Remember, this would be like the cost of storing rejected goods or transporting rejected goods, right? Someone rejects the goods, you have to move them to a different place. There's costs associated with this. That would be typical in a breach of contract action. Those are general damages, right? Special damages are damages that are unique to this particular plaintiff in this particular breach of contract action. So the special damages here are the $35,000 that this plaintiff lost based on not being able to invest the $15,000. So the special damages potentially is $35,000. The general damages is essentially the loss in value, right? This is just very standard damages, right? The value that the plaintiff should have received under the contract minus the value that the plaintiff did receive, right? So the general damages here would be very straightforward, right? Our plaintiff was promised $15,000. He was paid $0. So you would have like $15,000 in general damages, but you probably wouldn't even need to really discuss this because it's so obvious. I mean, yeah, he was promised $15,000 that wasn't paid to him under the contract. He would absolutely be entitled to that under general damages, right? The real question is the case of the $35,000 that would have come had he gotten the $15,000 and invested it. He could have had this gain of $35,000. And the question we're thinking about whether he's entitled to that money, remember, there's 2 requirements for these types of special damages. And it is probably worth noting, too, that we would be analyzing this under the umbrella of expectation damages, right? The normal measure of damages for breach of contract is expectation damages, which aim to give the non-breaching party the benefit of the bargain by putting the non-breaching party in as good as a position as he would have been in had the contract been performed. So here, very clearly, our plaintiff is asking for expectation damages. He wants his expectation interests, right? When we're thinking about that compared to reliance damages or restitution, right? He's not looking for recovering the money he spent in reliance on the contract. He's not looking for some sort of unjust enrichment or restitution. He wants his expectation interest here. He wants to get what he expected had this contract been performed as promised. He's saying, hey, look, if you'd paid me the $15,000, I was going to invest that and I was going to get this $35,000 gain. Because you didn't pay me the $15,000, I missed this investment. Now I lost my $35,000 gain I expected to get had you performed this contract as promised. So this is under the umbrella of expectation damages. And expectation damages in general must be foreseeable and proven with a reasonable degree of certainty. And usually typically where this is an issue is special damages, right? So here we're asking and deciding or determining whether the plaintiff is entitled to $35,000 based on this investment opportunity. Was it foreseeable? Question number one, was it foreseeable? And question number two is going to be whether the plaintiff can prove those damages with a reasonable degree of certainty. And remember, we already said as we went through the fact pattern that the answer to both of these questions was yes and yes. The reason that this is foreseeable, that the defendant, and when we're thinking about was this foreseeable, it's not necessary that the profitability of the investment be foreseeable at the time of the breach. It's enough that the fact of the investment is foreseeable. And here it was because designer told retailer that designer needed the cash to make an investment. This makes the damages foreseeable. The key was designer called retailer right here in the fact pattern. Designer called retailer and said, I need cash quickly to make an investment, right there in the fact pattern. He puts him on notice, right? Designer calls retailer and says, I need cash quickly to make an investment. Right there, it became foreseeable that he was going to use this money to make an investment. At this point, retailer tells designer, I need the cash to make an investment. Designer now has reason to know that he's going to use the money for an investment. That's all that's needed to show foreseeability. So that would have made the damages foreseeable, these special damages, this $35,000 loss and the gain from an investment foreseeable to the defendant. And the facts stipulate that he can prove this basically with a reasonable degree of certainty, right? At the very end of the fact pattern, it tells us that designer can prove that he would have gained $35,000 had he been able to make the planned investment. It tells us this at the very bottom of the fact pattern. So yes, if he can prove it, right, and it just tells us he can prove that he would have gained $35,000 had he been able to make the planned investment. So he can prove it with a reasonable degree of certainty. So he would be entitled to those $35,000 in special damages. He'd be entitled to the $15,000 he was promised in general damages and another $35,000 in the special damages that he was entitled to, because they were foreseeable and he can prove them with a reasonable degree of certainty. Okay, that was point number two, which takes us to point number three, which was about punitive damages. Here, the bar examiners were looking for examinees to conclude that designer is not entitled to recover punitive damages because such damages are generally not recoverable in a contract action absent tort liability. This was a very straightforward analysis. You probably could have summed this up for 10% of the total points here in one or two sentences, right? The idea is that generally in a breach of contract action, a plaintiff is not going to be entitled to punitive damages unless there's some sort of tort liability that would entitle the plaintiff to punitive damages. We don't have any facts here about tortious activity. So without any facts going to tortious activity, something that could then potentially bring punitive damages on the table in a typical breach of contract action, right? We're limited to expectation damages, monetary damages within the scope of expectation damages, reliance damages, or restitution. Punitive damages can really only come onto the table if we have some sort of tort intertwined in the fact pattern, which we don't have here. So that was point three, really small point here, only worth 10%. You just had to know without tort liability in a breach of contract action, there's not going to be punitive damages available to the plaintiff. But with that, that was everything the bar examiners were looking for on the February 2011 multi-state essay exam for this contracts question. With that, I'll leave you all to it. I wish you all the absolute best, and I'll see you at our next lesson.